So, Malaj, what's important here to note is that he cannot vote contrary to any direction issued by the political party. So, obviously, in terms of paragraph P, it's the political party which issues the direction, not the legislative party. And the direction is issued through the leader of the political party, normally the whip, or the leader of the political party. Such person authorized. So therefore the political party will authorize such person, and he is the whip. The whip term is not used in the 10th schedule, as you will notice. The term used is direction. Or by any person or authority authorized by this law without obtaining in either case the prior permission of such political party. Now, whose permission has to be obtained if I want to vote against the whip? Political parties. And political party is outside the house, not within the house. Within the house are only legislators. So you'll have to go to the whip, you'll have to go to the whip, or the person authorized, look, I want to vote against, or I want to make a speech against. I don't agree with this bill. And sometimes, actually whips do agree. It has happened so often with us. You say, no, these particular clauses, I don't allow me to speak, but I will vote for you ultimately because I don't want to violate the whip, but allow me to speak. And sometimes we are allowed. So a nominated member within 6 months actually can join a party. Not after 6 months. Then subsection 2 is very important. An elected member of a house who has been elected as such otherwise than as a candidate set up by any political party shall be disqualified for being a member of the house if he joins any political party after such election. I belong to that category, Malad. So, Malad, if I try and join any other party, Malad, I shall be disqualified.
Anglo-Indians.
That's right. That's for nomination, Malad, not
3.
Yes. 3 is a nominated member shall be disqualified being a member of the house if he joins any political party after 6 months. That's what I told your lordships. So paragraph 3 as it then stood operated on the assumption that there is a split in the original political party. A split in the legislative party would not have been a defense, even if it is more than 1/3.
There has to be a split in the original political party.
Now, how does that split happen? Because he makes a claim. Before all this happens, demonstrates in the claim that a split has occurred. Calls for a meeting of the original political party. Has a faction, has a resolution passed. Breaks away. Breaks away, Malaj. And then if he is 1/3, it's a defense. Even if he loses Malaj in capturing the party. So the splinter group of that party can be a separate political party. He will, because he is 1/3 in the legislature, belong to that party. Because that becomes his original political party. None of this has happened here.
The quantum of the split, interestingly, was not defined in terms of numbers. So long as there is a split, the 1/3 is in relation to the group representing the legislative party.
Yes, I agree, Malad. Malad, that split may be minority, majority, it doesn't matter.
So long as, there is a split.
There is a split.
In the original political party.
Correct. So, that's not the case here, Malad. On 21st of June, they were in Gujarat and they were in the Northeast. Only the legislative members. And they never said there's a split. They said, we are the Shiv Sena. So that claim was also not there.
Yes.
Now, let's kindly see this constitutional amendment. They amended 164 of the Constitution. Creates a lot of problems. That problem doesn't confront us in this case because most of these people then resign, join the other party, get elected, become minister. So there is some scope for challenge to this particular provision, its constitutionality. But be that as it may, we are concerned with the earlier part of this. That if you are disqualified, you can't be a minister. Now your disqualification is pending. Matter is before the Constitution bench. Matter is before the Speaker, whichever it may be. And you are appointed by the Governor.
And also there's a provision on the Representation of People's Act where they can't contest again.
That's right. Not for this, Malas. Not for the 10th schedule. That is for other corrupt practice. There is no period here. That's why I say this is subject to challenge.
Right.
Okay.
There, if you were for all kinds of other reasons, corrupt practice, and he's been convicted for X number of years. Now, what is happening in a ordinary case of a dharna on a road, a trial court convicts you for 2 years and you lose your membership of the Legislative Assembly. That's also happening. We can see it, headline news everywhere. What do we do? Can't keep on coming to court every other day. Your lordships also get fed up with us. Sorry.
Already.
How many times do we give you justice? So, now, kindly now come. So, therefore, now, the bottom line is, there is no concept of a split anymore. Then the statement of objects and reasons for deletion of the paragraph. Please see this, please mark this. The purpose of the amendment is that we will not allow you to destabilize the government by bulk defection. And that's exactly what has happened here. So you have to interpret the 10th schedule and its provisions to ensure that there is no bulk defection. And the concept of minority is over. Bulk majority also will be subject to disqualification. And 1/3 was a defense. Majority is not a defense anymore. There is no defense as far as a split is concerned in the legislative party.
Mr. Sibal, notwithstanding the deletion of paragraph 3 of the 10th schedule, the issue as to who represents the political party is still a moot issue.
No,
but that has to be resolved outside the legislative party. That cannot be still, according to you, resolved within the fold of the legislature party.
That question doesn't arise in this case because
no, I mean, we're not on this case, but that question as to who represents
that will happen outside the House.
That will happen outside the House. That cannot be resolved by the number of legislators within the House.
That's my only submission, Manoj.
Yeah.
How that is resolved outside the House is actually given in a judgment of this court in Brahmanand Reddy.
That's a matter of the internal, the internal constitution.
That's right. You have to call a meeting. You have to raise the issues. For 2.5 years, the gentleman was a minister.
The procedure, the bylaws of that party.
Yes.
But the forum is.
You have to follow those bylaws. You have to call a meeting. You have to resolve that issue, and then you can do all this, Manoj. When paragraph 3 was there. Otherwise, Manoj, what you're doing is exactly what the object says you shouldn't allow to do, bulk defections. Toppling the government. As I said, what this would result, if you were to uphold this, Manoj, my humble submission, if you were to uphold this, then any government can be toppled, Manoj, for the simple reason you take those people, become majority, appoint your speaker, Manoj, and have a trust vote and you are in government. You don't need anything else. You don't need to have a split in the political party. That's a matter of a dispute that will arise and it will go to courts and the courts will decide in their own time. In the meantime, the 5 years will pass. So if you wanted to remedy this menace, you can't allow the perpetuation of this menace by recognizing a split in the legislative party as if there is a split in the political party which is not even addressed, which is not even claimed. What is claimed is that we are the party. Now, we are the party can't be claimed within the legislative party. Well, for 2.5 years, I'm sorry.
For 2.5 years?
He was the minister. This very government never raised an issue. There is no public document saying that he is dissenting or he is a conscientious objector. Nothing. No evidence, no document filed, no evidence of that, no public statement, no newspaper report, nothing. He was the leader of the House on 21st of June. And overnight, Manoj, facts stare you in the face. The only way, Manoj, this is not what Parliament will be ready to do, the only way to remedy this is to have a 5-year period of no public post moment you defect. No minister, no public post, no public sector, no nothing. All this will stop. That's the only way. 164, 1B now gives you a way out. Instead of defecting, you can resign and then you become minister. You were a minister before, all you have to do is resign. This is the only way. If you want to maintain morality in public life, you will not be given any public office, no governorship, no remunerative post.
Kind of cooling off.
I'm sorry?
Cooling off of sorts.
Yes. Even in 361 Mullahs, in fact, disqualification for appointment on remunerative political post. Capital B Mullahs. If he was disqualified, he can't hold a remunerative post. Actually, 91st Amendment Mullahs was very careful in trying to sort of settle part of the problem. But one thing was clear, they did not allow for bulk defections. Now Mullahs paragraph 4, if I may read Mullahs of 10th schedule. 4.1 Mullahs, a member of a house shall not be disqualified under sub-paragraph 1 of paragraph 2, where his original political party merges with another political party. And he claims that he and any other members of his original political party have become members of such other political party, or as the case may be, of a new political party formed by such merger. So, Maharaj, if the Congress or if a small party in a state merges with another big party to form a new party, that becomes his original political party. Therefore, a member of a house shall not be disqualified where his original political party, maybe a small party, merges with another political party, and he claims that he and any other members of original political party have become members of such other political party, that is, they merge into that party, or, as the case may be, of a new political party. Both of them may form a new political party formed by such merger.
So A merges with B, or A and B merge together to form C.
Form a new party. So therefore, no disqualification. It's a merger of the political parties. Or have not accepted the merger and opted to function as a separate group. So I say, look, I don't accept the merger.
There's no compulsion to merge.
There's no compulsion. I may be majority, I may be minority within the legislature.
This will be called the unattached member?
Yes.